Hello, Dr. Bechtel here. In this lecture, we're going to cover Chapter 3 of A Practical Guide to Legal Research and Analysis for Paralegal and Legal Studies Students. This is by Margaret Phillips, published by West Academic Publishing in 2020, I believe. All right, so this chapter covers what you need to know about court structure, case law, and our three branches of the government. This is kind of a complex area, but we're going to practice some areas, do some practice work in this. So for now, let's just move on, and the skills you're going to build from this lecture are: recognize which court rulings are authoritative, meaning of precedent, or mandatory or persuasive. We're going to identify different types of case law, such as common law cases versus cases applying other sources of law. And you're going to demonstrate an understanding that multiple sources of law may be necessary to solve a problem, and demonstrate understanding that legal sources can be interrelated. Case law means court opinions from the judicial branch. Case holdings within the case law are legal rules. And the only source, and case law is the only source of law where you can actually see the legal reasoning process. That is, courts applying legal rules to the case. Not all cases are created equal. We have to look first to the definition of precedent. Precedent is a legal principle or rule established in a previous case, and that previous case will either be mandatory, where later decisions of courts must follow that legal rule, or persuasive. Later decisions by courts can, but don't have to follow a persuasive holding. For a court, so when deciding a subsequent case, when deciding a subsequent case, it can be either mandatory or persuasive. First, we need to look at how the legal rules fit into the court system. In the United States of America, we tend to have in every state and in the federal the three levels of courts. We start with the trial court. That is where the cases begin. And there's a mid-level appellate court, sometimes called intermediate appellate court, and a court of last resort. The trial court decisions have less precedential value than those that are decided by higher courts. If we move up to the mid-level appellate court, procedurally what happens is a panel of judges hear the oral arguments by the attorneys, and they only hear arguments about questions of law. They also file appellate briefs explaining their side of the case. And typically, in each state and in the United States federal system, so typically court systems have one or more mid-level appellate courts. For example, in Florida, our state court system has 6 mid-level appellate courts, and they're all within what is called District Court of Appeals. So that is geographic, and each district is arranged geographically and contains the counties that are within the state of Florida. So Second District Court of Appeals in Florida is where we are, and that's Sarasota County, Manatee County, and Hillsborough, and Sarasota, Manatee, DeSoto, Hillsborough, I think that's it. And the 6th District Court of Appeals just emerged, was just started about, I'm going to say 4 or 5 years ago. So the panel of judges are typical to the mid-level appellate courts in America, both state and federal. The court of last resort has discretionary jurisdiction. So what we mean in converse of discretionary is if I have a case in the trial court and want to appeal the decision in the trial court, I'm just going to take it right up to the mid-level appellate court. They don't have discretionary decision-making power, as in they take it. It's here's my appeal, and they take the appeal. The court of last resort, however, being the court of discretionary jurisdiction, they set their own agenda. They typically take on novel questions or questions of first impression, and they resolve disputes between appellate courts. And they have all of these traits here. There will be a panel of judges, oral arguments, appellate briefs, only dealing with questions of law, and then, of course, we don't have more than one court of last resort in a state. In the United States, there's the United States Supreme Court. What else? So the court of last resort. Okay. Now, to understand which cases are more valuable, which means mandatory versus persuasive, you need to understand what is the basic structure of the courts in the jurisdiction, whether it be state or federal, where the cases were decided. So imagine you're reading cases. You're looking at case law. You're looking at the back story from previous precedent. So jurisdiction will come into play because it means the power of a court to address or act on a legal issue. Geographic jurisdiction and subject matter jurisdiction are two common forms of court jurisdiction. Trial courts have the broadest jurisdiction, and it's called general jurisdiction, meaning that the trial courts have general jurisdiction over a variety of matters. The amount in controversy applies, and trial courts are of limited jurisdiction. So general jurisdiction and limited jurisdiction, it's kind of hard to hear those two words together, but just imagine the general jurisdiction is over a variety of matters. Trial courts, for example, have jurisdiction over traffic cases. They have trial courts in Florida have jurisdiction over family law cases, blah, blah, blah. But at the same time, within that whole trial court system, there are courts within it of limited jurisdiction. So the general jurisdiction covers a variety of matters. The amount in controversy will matter as well. However, in trial courts, they do have courts of limited jurisdiction. For example, traffic court, criminal court, family court, etc. All right. And further, the higher it goes, the more precedential the value of the case is. Trial courts will have that, am I repeating something here? Okay, my apologies. So again, trial courts have the broadest jurisdiction called general jurisdiction in trial, and they're limited jurisdiction courts within the trial court system. In the mid-level appellate court in Florida, again, that's called the intermediate appellate court system. The first appeal from the trial court is taken to the mid-level appellate court. And it also has broad authority, and it's geographic authority. District courts of appeals, for example, in Florida we have 6. Each of those 6 has jurisdiction of matters within certain counties within the jurisdiction of each DCA. So each DCA has its own set of counties in its bucket that it has jurisdiction over. So if I'm in Manatee County and I have a trial decision I want to appeal, I would take that Manatee County appeal to the Second District Court of Appeals, which is the Court of Appeals that has jurisdiction over trial court decisions in Manatee and other counties. Discretionary jurisdiction we talked about in the previous slide. That's the court of last resort, has discretionary jurisdiction, and a writ of certiorari is the method used to request that the court take on a decision from the mid-level appellate court, and it's the court of last resort. And it's, again, discretionary. The court decides, and as pointed out in the earlier slide, usually taking on novel problems, or what was the other one? Novel problems or courts or problems of great public import. Next, we'll look at the same precedential value of cases. And I know, so this is repetitive, but I wanted to do it like the book did, just to give you even a little bit more, more aligned with the textbook. So trial courts decide questions of fact. Appellate courts, on the other hand, they decide only questions of law. Note that trial courts, though, they make decisions about both fact and law, and some decisions will involve a mix of both. The mid-level courts, both state and federal, decide strictly legal questions. Example, did the trial court provide the correct jury instructions? Or whether the quality and quantity of evidence was sufficient to support the verdict. And then the discretionary jurisdiction, these are strictly law questions, such as whether a given statute, regulation, or case decision is constitutional. And they also look at disagreement among the federal mid-level district courts regarding the same. So if one circuit, federal First Circuit has, we saw this in family law, constitutional matters like same-sex marriage. All these states had come up with their own decisions about the Defense of Marriage Act and whether that is constitutional or not. At the state court of last resort in many states, there was one yes, it is constitutional, and in another state it's not constitutional. And that's what they mean, what's meant in the book about the disagreement among the federal mid-level appellate courts regarding same. So it happens on the state level too. But the federal courts sometimes also will have conflicting opinions, and in the United States Supreme Court, the court of last resort, will sort that out. Now, the other thing about our court system is we have citations to case law and other rules of law. And so this is an example of how the cites to a case tell a story. If we come down to the last in the trial court, this same case, Standish v. Law School, found its way in the trial court, to the mid-level appellate court, and then to the court of last resort. However, at the trial court, there was a decision. It was rendered in 2016. And the decision is a published decision in the federal supplement. This would be the third issue of the third series, basically. We won't get too involved in that, but it's because it's just to maintain some order. They have different, it's like a new edition. So the old edition is the old cases. Supplement 1 would be, series 1 would be older cases than series 3, for example. But staying on point, this case started at the trial court, and in federal court, the trial courts do have a reporter. Their reporter is called the federal supplement. It's a federal case. That's why we find that trial court decision in the federal supplement. It's abbreviated with F-Supp. It's also a case decided in 2016, and so this parenthetical is what it's called, is telling the reader of the citation that this case is from the District of Massachusetts in 2016, from the district court, a trial court in Massachusetts. So they weren't happy with the decision. Somebody wasn't, went up another level to the mid-level appellate court in the federal system. Now the case citation, which is that story it tells, now we see that it's in the Federal Reporter 3rd series, so that's how we know that here, and means it's a federal case. The parenthetical shows us it's in the First Circuit, and it was decided in 2018. So this tells a story too. This is showing me, oh wow, this is a trial court decision. And then if I were to read this case citation, I would say, oh, this is from the mid-level appellate court in the federal system. And then we go up to the decisions of the court of last resort in the federal system, and the citation changes a bit. The case is located in U.S. Reporter, United States Reporter, that is, in volume 101, page 200. So this first number you see is always the volume number, and this second number is the page number where the first page of the case shows up. So it's very consistent throughout all of case reporting. Again, so this case comes from the United States Reporter. It contains, that particular reporter set contains only SCOTUS, Supreme Court of the United States opinions, and it was a 2019 case. So from 2016 to 2019, this particular case, Standish v. Law School, climbed the ladder to the court of last resort, and there's a published opinion here, and here that can tell you the journey of the appeals. Of course, this would be a matter of law. They're appealing a legal topic, not a factual topic. All right, so precedent and stare decisis. Stare decisis is a way that the American court system ensures consistency and predictability in the law, and so the judges are guided in making decisions based on past rulings. These precedents can be either set by higher courts, and they must be followed by lower courts within the same jurisdiction. And this practice of the courts is called stare decisis. That's a Latin term, and it means to stand by things decided. All right, so a little more about precedent and stare decisis. All precedent is not created equal. That's point one. Point two is court decisions, they can be either persuasive or a persuasive precedent or mandatory precedent. Mandatory precedent means it must be followed. Persuasive means it may be followed, but the courts don't have to in that jurisdiction. And so when we're looking at case law, we want to take into consideration two things. One is what level of the court it comes from. Because, generally speaking, the higher the court, the more valuable, e.g. persuasive, the precedent is. And also look, number two, at the jurisdiction. And in this context, what we mean, not only the geographical area in which it's being raised, but also, are you reading a case from the state court or the federal court? Because that's going to matter whether it can be applied. So we'll go any further with that, but those are the two considerations when you're looking at case law to decide whether it's stare decisis. Because all precedent is not created equal. They can be persuasive or precedent, and these two considerations are what drive the decision. Is this persuasive precedent or mandatory precedent? And what can make the difference between persuasive versus mandatory is the level of the court it comes from, because let the decision stand, and it penetrates down, but it penetrates down in a mandatory way when it's in the same jurisdiction as the case you are trying to prosecute or defend. But the top court is, in federal cases, the top court is the boss. So we're looking within our state law federally, okay? So we're looking, and so in our state, we have, if it comes from our state, there is more precedent than that from another state or another. I'll stop there. And then mid-level appellate courts, their decisions require you look at the geographical jurisdiction. What that means is those in your geographical area have the most precedential value. And of course, the higher on the level it goes, the higher court it goes to within your geographical area, you have the most precedential value. It's a mandatory precedent. Those in the federal court circuit in which your case is located will have mandatory precedent also. The cases from outside the circuit where your case is located are only persuasive precedent in your jurisdiction. So the federal system and the state system, we'll get onto that in the next slide. The top court is the boss. The higher it comes from, that's what we've been emphasizing throughout this already in the earlier slide of the pyramid. The higher the court it comes from, the more persuasive, the more precedential value it has. But we also can't just pick any higher court. We are more persuasive, mandatory that is, when we're in the same circuit where my case is located. Outside of that, it's simply persuasive. The courts do not have to follow that precedent. Let me see if there's anything else on this I want to add. And yeah, this is what I thought about. This SCOTUS, Supreme Court of the United States, is generally, I should say, always a mandatory precedent for all constitutional questions. So keep that in mind. That's why when the Supreme Court makes a decision, everybody gets pretty excited, whether they like the outcome or not. All right, let's look at the same principles in state cases. It's the same. This is a carbon copy, except now we're looking at the state case paradigm. We're still looking, and we're looking for cases in our state because our state has more precedential value than from any other state. So I'll give a quick example. When I lived in Wyoming, I used to joke, or we as a whole in law there, we used to joke that there is no law in Wyoming because it doesn't have the same number of appellate court decisions for precedent to be drawn from. It doesn't because it's smaller in population, it sees less work than other states. So Colorado was our sister state in Wyoming. And it had precedential value for, I would just say, for geographical reasons. If you think about it, Wyoming and Colorado, they're right next to each other. They have the same climate. They have the same similar problems, each state does. They both have a lot of mining and natural resource things going on. So there's a similarity. They have the same kind of environment in many ways. Unlike if I were comparing Wyoming to Florida, Florida has fruit trees. I wouldn't find a fruit tree statute to apply in Wyoming because Wyoming doesn't have a fruit tree statute. I wouldn't say let's use that statute. I mean, we might find a reason. There could be something pretty far out. But my point is that the boss in Wyoming would have been Wyoming cases. But because we didn't have that case law or precedent in Wyoming, we would reach into the annals, if you will, of Colorado to find what we're looking for. And it's more valuable, but it's still mandatory. Okay, so it has more precedential value, but it's still, persuasive, not mandatory. Okay, so mid-level appellate courts, those decisions require, again, we need to look to the geographical jurisdiction. Let's just put it easily, like the realtor says, location, location, location. That's what we're talking about. Those in your geographical area have the most precedential value, and whether they're mandatory or precedent, mandatory precedent would, the closer you get to home, to your location, the mandatory precedent, the more the mandatory precedent will emerge from it. The only cases from the mid-level appellate court for your jurisdiction will have mandatory precedent. And cases from mid-level appellate courts outside of your case's location will have persuasive precedent in your jurisdiction. Back to the Wyoming, Colorado example. But if I'm in Wyoming and I find a state case in Wyoming that says what I needed to say, I'm like, hey, I'm happy. And mandatory precedent it is. And it's from a mid-level court of appeal in Wyoming, which I don't think they even have they don't have a mid-level court of appeal. They go straight to the Supremes. We don't have a mid-level there. But little difference between the states. All right, so this consists of 2 slides, which is why you see the word 3 here, but there's not 3 points made here. This continues on to the next slide, so don't go, hey, Dr. Bechtel, are you not learning how to count yet? I do know how to count. All right, so there are generally 2 types of cases out there in the labyrinth of case law. Courts will interpret and apply another source of legal rule, such as a constitution, an administrative regulation, or a statute. So that's one type of case, one type of decision, an interpretive decision where they're applying other rules besides cases. However, and cases that rely on and develop legal rules, those are contained only in case law. So they're not these legal rules are made by judges in their common law cases. In a minute we'll use some examples of the types of law that you would find mostly to fall under the common law principles. So the case itself, and so that's 2 types of cases: interpretation or development. So we're interpreting a statute, etc., or we're developing a legal rule, and it's judge-made law or common law. All right, the case itself, the court's decision in the case, the case holding, is yet another form of legal rule. So courts apply statutes, etc., to interpret. Courts apply precedent to interpret, or they develop judge-made laws. But the case itself has a court decision, and that is another form of a legal rule. This is the second slide. This comes from diagram 7 of our textbook. And again, I just reiterate, there are 3 types of legal rules. And I just went through those, but I wanted to do this little exhibit. A court's decision on how a legal rule applies to a set of facts. Common law applies a legal rule from a past case. Common law is state law only. There is no such thing as federal common law. Case law is where those legal rules from statutes, administrative regulations, or constitutions, as well as case law that likewise applies rules from those sources, those are one type, the second type of legal rule. And then the case holding, that's a decision of a specific court on how the legal rule applies to a set of facts. Now, common law is judge-made law. Black's Law Dictionary provides a definition of common law, and it's the rules and customs that do not rely whatsoever on the legislature. Back to the term statutes. Common law was imported from English case law, and common law can be either civil law or criminal law, but most states have codified their criminal law. And states can codify other common law, and they do that often. Decisional law or judge-made law, that relies on prior court decisions. And negligence is an example of common law. We'll get into that in a minute here too, I think on the next slide. Yes. So let's look at this thing, common law, and find out if a case is common law. When we first start reading a case, we're going, okay, what am I reading here? Is this what kind of decision is this? Are they applying a statute, etc.? Are they applying a rule of a kind other than common law, whatever? So if you're reading state case law, so again, that magic word is state, you're looking, and for the issue you're looking at, Does the case solely rely on past court decisions with no reliance on statutes, regulations, or the Constitution? And if these two answers are yes, then you are dealing with common law. Now, in a minute, we're going to see how one of the third or fourth objectives of this lecture we're going to, where there might be more than one source of law in deciding a case. But common law, just looking at, am I dealing with common law? It would be a state case, and is it relying on past court decisions, or what's called precedent, with no reliance on statutes, regulations, or the Constitution? Now, the common law topics in your state, in every state really, is contracts, property, and torts. Meaning, there may be some statutes where they've codified, where the legislature has codified some of these principles, but for the most part, it's common law. All right, here's a sample case, and this is in our textbook. The sample case starts on page 89, and I'm going to read a little bit, and by the way, here we go, we're going to just do that. So in this case, we have the New York State Appellate Court, mid-level appellate court. All right, so we know from looking at this, it's a state case. It tells us something, doesn't it? It's in the New York State mid-level appellate court. And case name, Carr versus Bus. It's an opinion. So and here's the memorandum by the court. So these are the facts of this case that the court is looking at. Plaintiff sued for damages for personal injuries suffered as a result of a two-car collision in which blah, 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 blah. The plaintiff suffered injuries, and the accident was in 2019. Now, we're looking at the case now, and we're reading, going, what did the court decide? Well, first of all, it looks to me like this case, Gambino versus City of New York, is a state case. Why do I know that? Well, I see a lot of clues. In this case citation, I see an official state recorder noted here. Here's an unofficial state reporter noted here. The name of the parties is Gambino versus City of New York. Doesn't really tell us a whole lot, but oftentimes the names, after you get used to citation, you'll begin to just be second nature to know pretty much what that case is about. For example, if it says state versus Gambino, it's probably criminal. All right? But in this case, it does not reflect that the state is the party, but a city is. And so I believe this has to do with negligence, right? So although the defendant Bus had a duty to explain how he rear-ended the plaintiff, oh, I'm sorry, I was going to get back to the next, oops. I thought I had no, I'm sorry. So the defendant had the duty to explain how he rear-ended the plaintiff in order to avoid the conclusion that he was negligent. So he was not able to do so, according to the police report, and Bus simply told the officer that he was grooving to the music, and he lost track where he was. And in the absence of any reasonable explanation, the rear-ended vehicle is negligence. Therefore, the trial court's grant of summary judgment to the plaintiff, Phyllis Carr, is affirmed. So that's a sample of a case. Now, some cases apply another type of legal rule, statute, administration of regulations, or a constitution. And the court's interpretation and application of legal rules is important, and you shouldn't go forward with applying a legal rule without checking to see how the court in your jurisdiction for mandatory authority, or those outside your jurisdiction for persuasive authority. So precedent has to support your interpretation of a legal rule. That's what we're using it for. Remember the three types of cases. So here's a sample case again of Carr versus Bus. Same stuff as we had already in the previous example. And we see still it's a sample case out of mid-level appellate court. And then we get to the next page, the next slide, and we're on the case decision 2. And now we're looking again at where is this case, what type of law is the court applying? Well, it's state law, correct? So we're looking to see if this is, if this case that we're reading, car versus bus, is a common law case. That's what we're trying to decide in this slide. So we are seeing that state law is being applied, and then it's relying on something other than Gambino. It's talking about a Rule 3212. So we're applying state law, and it is state rule, by the way. So we're dealing with state law here, and this Gambino versus City of New York is indicating that it's common law. Now, what the author is getting at here with this slide in the book on page 90. So you see that cases being applied, Gualia versus Alpha, and it's a state case, and also a rule 3212. It's a rule of procedure from the court system that's being applied here. You'll see these cases are applying both a rule, we call that a regulation, the 3212, and it's important you don't go forward applying the rule without knowing what courts have done in the past. In other words, on the previous slide we were saying common law, but on this slide we're seeing a rule. And on page 91, you can see it in the middle. I'm going to read this out loud. As you can see, this sample case now has an additional rule in it, and it's referencing this Civil Practice Law 3212. It's a reference to another rule, and it specifically is a statute that lays out the procedure for the specific type of motion, which is called a motion for summary judgment. And that type of motion is a request for a court to a court for something, and that's what a motion is. A motion for summary judgment is a request to a trial court to make a final decision on an issue in favor of the movant. So whenever a party wants a court to make a decision or grant some type of relief, they'll file a motion and move the court for the specific relief. But in this case that we're looking at on this slide, the movant, the party making the motion, is the plaintiff, and she moved for summary judgment and asked the court to decide the case in her favor without a trial. And it basically is saying she believes the evidence already proves without a trial that she should win the case. So Carr, the plaintiff, made the motion because she was simply in a stopped car doing nothing wrong when she was hit from behind by someone who was grooving to the music. And there's precedent establishing that summary judgment is appropriate. Specifically, my apologies, I was on the wrong slide. I will try to cut out that last commentary because it was getting confusing and I could feel it because I felt confused. Again, we're dealing with state law, and does it rely on something other than the common law of Gambino? And yes, indeed, it does. It also relies on another rule, and it's a rule of court, so it's likely a statute in anywhere state this is located, New York, and the court is relying on something other than Gambino, the common law. It's also relying on a rule of civil practice and procedure. Now, back to this slide. So this is where I meant to be on page 91. In the above case, this case I should say, the movant is making a motion for summary judgment, and it asked the court to decide the case in her favor. And she did that applying the case of Gambino, because Gambino on the previous slide was explaining that it's prima facie evidence of negligence. And then it goes on to look at this rule also, the civil practice statute. And the plaintiff made the motion because she was simply in a stop car doing nothing wrong, just like in the Gambino case, and she was hit from behind by someone grooving to the music. And there's precedent establishing that summary judgment is appropriate, and that our friend that was grooving to the music had the obligation to submit proof that he was not negligent. So in short, in the above example, there are two rules within the case. There's the common law, which was the Gambino case, and the procedural rule called the civil practice rule, which is further explained by Guilia versus Alpha. So that is explaining the not common law, or the statute. Guilia is applying the statute. As such, it's applying the statute as an interpretive form of decision. So we have common law, and we have a rule from the statute. And then we have a case, Guilia versus Alpha, that is interpreting the statute and under the circumstances of this case. So this is an example of the court relying on a case, explaining a statute or an aspect of a statute. And in this case, the type of evidence that the defendant could have introduced to meet the requirement of the civil practice statute, therefore being able, if he was able, to defeat the summary judgment motion. So that case, Guilia, provides, the court refers to that case to provide a rule and an example of what the defendant could have but did not do. So there's another legal rule. So in reading the case law, you can see many, many rules that the court discusses and relies on. When you're researching a legal question, be sure to pay attention to which rules cited by the court are potentially relevant, and be sure to check them out. All right, so now we go on, I believe, to case holdings. That's the application stage of the course. They're applying common law, and they're applying interpretive case law that interprets a statute. And that's the application. And then we go on to the holding of the case. The court's holding is another source of legal rule. We talked about that in the earlier slide. And the holding is the final decision of the court that you're going to rely on. So you need to discern, as you're reading, between the court, discern between when the court is engaged in reasoning and discussing, which is application, versus when it's pronouncing its final decision in the case before it. And sometimes this is pretty simple, and sometimes it's not. So in this case, we know we have a holding when it's clearly announced, hold or holding. In this particular example, it was clearly announced. So we don't always see that, and you wish you really, especially when you're first starting your research and reading cases, you want to see it a lot, but you don't. But that's it. All right, so advice for research investigating various sources of law. So this is why we covered all of this to also help you see that there are different sources of law that come together. Like in that sample case, there were different sources. So we look for the legislative law in this area. And by the way, I always recommend students start with your statutes. If you're in a state case problem, look in your state statutes first. If you're in a federal, look in the federal statutes. You might also check the state and federal regulations. We'll go into that next. But I like to begin with the legislative stuff. I look to see if there's anything codified. That way I can find out, am I going to be dealing with a statute that I'm going to find cases that interpret it, or am I dealing with the common law? So what happens with legislature, they can amend, what the legislature does is they'll amend statutes when they're declared unconstitutional by courts. They can amend or pass new statutes if it disagrees with the court's interpretation. And plenty of examples of that. And then judiciary, that's where we get that interpretation and application of all types of legal rules. The court can rule, they can rule that an executive order, which is an administrative function of the United States government, whether it's invalid or unconstitutional. The judiciary can rule a statute, is unconstitutional. And then with the executive branch, we've got the legislative branch, the judicial branch, and the executive branch. They're enforcers, and they amplify the statutes by promulgating administrative regulation. So they fill in gaps. That's really a helpful thing to remember about the executive branch of government. They do gap fillers. The legislature might pass a law, a statute, and then delegate enforcement powers to an agency. And the agency, though, will develop and promulgate administrative regulations, and so that's part of the executive branch. But the executive branch can issue executive orders, and they can veto legislation. So there are multiple, there are different search strategies that you're going to look into this week or soon in this course, and we're going to need to check all sources of law. So we can use multiple keyword searches, we can check multiple jurisdictions, we can check multiple secondary sources too. Remembering from previous lecture that primary sources are the law itself. Secondary sources are text about the law. This textbook, for example, is text about the law. It's a secondary source. Your textbook in Intro to Legal Systems, that is a secondary source of the law. It wouldn't be, I wouldn't cite my textbook in a case, in an appellate brief or something, but I'm just trying to make that understood. And I apologize, I'm almost finished, but my dog is going to start barking because it is 3:54, and he starts to sundown, the little brat. I love him, but he has dementia. Okay. So, interrelated sources in legal problems is explained here. We have example 1, state criminal law and civil regulations is the subject of this. So Cindy Lou got stopped by a state trooper for speeding. And then the trooper discovered that she had been driving while intoxicated. Cindy Lou most likely would have violated 2 statutes. The statute regarding speed limit and the statute forbidding driving while intoxicated. However, add to the mix that she refused to take her breathalyzer test. So the issue, which is what we're going to work on in this class, is developing issues, is that she violated the speeding statute, but what are the repercussions for refusing the test? And so where would we look? We'd check the relevant driving while intoxicated statute. And I point out here, annotated statutes are very helpful because they will lead you sometimes to other sources like court rulings that interpret the statute under some circumstances that may or may not look like the Cindy Lou case, but we can we can use the annotated statutes because they'll show cases where that statute has been interpreted by the courts, and we can look at that. So it's a rabbit hole. It really is. You keep digging deeper with legal research and digging deeper and just making sure that you're checking everything that you can check. Secondary sources also will have some citations to cases, so that's a nice way to find your way into some case law. So this is how you can cross-reference and find other rules of law that explain your problem. Example 2 is federal and state employment statutes. What if Evan, a manager, had a highly unfortunate tendency to physically assault women colleagues at work and then dock their pay for refusing to promote them if they complained, or refusing to promote them if they complained? So what does the word assault trigger for the researcher? Well, assault triggers for me criminal law statutes. What does employment environment trigger for the researcher? Well, both federal and state employment law exists, so we would look to statutes, administrative regulations, and case law. And because statutes and administrative regulations tend to have a lot of interpretation, that's where the case law really gets handy, as interpretive. Last slide, example 3, common law in possibly state statutes and administrative regulations. So suppose Juan tripped on one of the outdoor stairs of his friend's apartment building and fell, breaking his leg. And suppose that the steps of the staircase had not been repaired and were unevenly spaced. Suppose also that the landlord that owns the apartment building, Oliver Hazard III, knew that 2 other visitors had tripped on the same step. So we're looking at negligence because it has to do with the property, and the person has fallen on the owner's property. And that's state common law because there's no such thing as federal law. We would look for common law. We would check case law. And a word search that we might use for that are fall, steps, injury. Those are ideas. And I also put landlord or rental in there, so you could also find that those are helpful avenues for search terms. Reading the cases, you're looking also, when you get to that point, you're looking also for state statutes that might be cited in the cases. So I guess there's a reciprocal nature in reading case law. It informs about statutes and regulations, etc., that might also be applicable. And it informs about interpretation. It informs about decisions in common law that are found in case law as opposed to statutes unless they're codified. And it could be referenced, and you could find references to state statutes and regulations that spell out details of the landlord's duty. So that was a lot, almost an hour, and I'll stop right there. And I appreciate your listening ear.